Well, good morning. We're going to call this session of the City of Port Orchard Land Use Hearing Examiner to order. It's just after 10 a.m. on March 31st in the year 2016, and we're here this morning to convene an open record hearing on an application for preliminary plat approval. The application is known as Stephanie's Meadows. It has a file number of subdivision 15-02 in the City of Port Orchard system. I'm Ted Hunter with Sound Law Center, who is the hearing officer chosen by your mayor and council to hear and decide certain land use applications and appeals. This is one of those that is assigned to the hearing examiner for decision in your municipal code. The reason we hold an open record hearing is to give an opportunity for me to collect information in an open setting from three different sources. We have with us today professional staff with the city, a professional planner, or two planners, engineer and also fire, here to assist in reviewing the application. The planner has prepared in advance of this hearing a staff report that reviews the application with reference to the criteria that are in the municipal code, and she made a recommendation with a number of conditions. Copies of that report are available at the front table as you enter the chambers. And if you haven't had an opportunity to review that, now is a good time to pick one up and look at it. So we get information from the city staff. Also, the applicant is present here today, and it is the responsibility of the applicant to show why the application should be approved as submitted or with conditions. So the applicant has a key role in this open record hearing. The third source of information is from citizens in the City of Port Orchard that have information about the application or about the area in which it's proposed to be developed. And I take information from anyone that is here that has questions or comments or concerns about the preliminary plat application. And as you present information at the podium here in front of the room, it's a tricolored microphone, it looks like now, something new.
It is not necessary for this hearing.
Oh, okay. We have flags and colored recording devices, but don't be intimidated. It's a podium that allows you to make certain that your testimony is recorded. This is the only opportunity to present information, and the decision I make is based only on the record that we create in this hearing room today. As you do present information, we ask that you testify under oath. The other information I rely upon are documents that have been presented to me. I have a number of them that I've reviewed in advance of the hearing. They've been listed as Exhibits 1 through 33 and generally consist of the application itself, the environmental review that took place under the State Environmental Policy Act, the notice of application and notice of this hearing today, and a number of departmental reviews that had comments on the application. And this set of exhibits is unique in one way in that there was a number of comments that were nicely prepared, very concise and organized by surrounding property owners that raised a number of concerns with the application, and then exhibits that show how those concerns were resolved. I have some questions about that, but that is a unique part of this record is that process of comment, city involvement, and sharing the comments with the applicant, and then it appears to be resolution of most issues, but we'll find out more about that. So those documents, Exhibit 1 through 33, I'm now admitting into this record of this hearing today. And if there's any questions about those exhibits, we do have copies available to review at the staff table here in the front of the room. Okay, I think we're ready then to begin with the testimony for the hearing. I turn first to professional planner, Ellie Davis, who's here this morning, that prepared the staff review and recommendation. and ask how you would like to proceed. Would you like to present information at this time, or do you want the applicant to present? What is your preference?
We can certainly let the applicant present the application first if they would prefer. Do you have a preference?
Well, you might give just a general summary of it. I have a couple of questions for you, and then we'll turn to the applicant.
Okay.
So first I'll ask you to take the oath. Do you swear or affirm to tell truth and testimony you give today?
I do.
Thank you.
So we have before us, as Mr. Hunter has introduced, Stephanie's Meadows request for a preliminary plat or a subdivision into 12 residential lots on the north side of Fireweed Street, as depicted in the map that will be available. The subject site is zoned R8, or 8 dwelling units per acre, and is located in a medium density comprehensive plan designation. And those are my initial statements on the application.
Mm-hmm. Yeah, thank you. And your staff report we do have included as one of the exhibits. And in that staff report, you review the criteria. And one set of criteria you referenced is what you refer to as an interim subdivision code. And I wanted to ask you about that. Is this one of the first subdivisions? There may have been one or two others, but one of the first that is being reviewed under that code?
This is. The City of Port Orchard adopted an interim subdivision code on September 8th, and that code was identified as ordinance number 015-15. That code was in effect until January, I believe, and then was replaced by an updated version of that code. The hearing for today, Stephanie's Meadows, was submitted as a complete application on December 2nd of 2015, which would vest it to review under the codes in place between September 8th and late January, I believe. So that is why I have reviewed this application under ordinance number 015-15.
Okay. And if one wanted to review that ordinance, it's not now within your codified municipal code. Is that correct?
It is not in our codified municipal code, but it is available on the City of Port Orchard website and is also available in hard copy from our office or the clerk's office.
Okay, that's good to know, because if one looks at the municipal code online, there's a chapter 16.72, which this ordinance that you just referenced is intended to replace. Is that correct?
Yes, it is.
And that's important because as we review applications, the guidance that we're given is in the current code. So I really appreciate that you took time in your staff report to be very specific about the idea of vesting. And that's a big deal in the state of Washington, is which code are you vesting to, because there can be changes from time to time. Now here you mentioned there was an updated code in January. Were there any major revisions, or was it more tweaking? Do you recall? Is there anything we need? Now, this is vested to a prior code, not the current interim code.
I believe it's mostly tweaking.
Mm-hmm.
Director of Community Development, Nick Bond, has actually worked most directly on that new
code.
Well,
and the reason I'm asking is that although there is vesting to a prior code, sometimes there are things in a more recent code that voluntarily or that may be agreed to by an applicant to adhere to. So vesting isn't always mean that you have to comply with the previous code. It's an opportunity to also bring in any new regulations that might be more appropriate.
I have not identified any new regulations adopted in the updated code that would pertain to this subdivision.
Okay, and that's really what I wanted to know. This isn't a hearing on all the details of the code, but I think it's important, as you just testified, that you did look at the code that was tweaked, as you put it, in January, and you didn't see any provisions in there that you thought should apply to this application.
I did not.
Okay, very good. The other thing I was curious about in your staff report is your discussion of comprehensive plan provisions. And I think that's on page 3 of your staff report. And you referenced two areas of that plan. One is the discussion about what the residential designation might mean, and the other is transportation policies.
Yes.
And my question is, did you do that just to orient us to what the comprehensive plan states, so that we know we're consistent with the comprehensive plan? Because the details now are in that, what we call Ordinance 01515, in the subdivision code itself.
Yes.
So the comprehensive plan provided you general guidance, is that correct?
Yes, the comprehensive plan does guide all development within the city of Port Orchard. So it is kind of a general underlying plan for our community.
Okay, because you referenced just a couple of policies. There may be many that apply, but you picked out ones that you thought were most relevant.
There are many that apply. We have recommended conditions for off-site roadway improvements as part of this development, and I did reference a couple of transportation element items that did discuss some of the improvements that we were looking for.
Okay.
Primarily sidewalks and provision for non-motorized transportation and yeah.
And with reference to what you just mentioned, like sidewalks, your staff review in the staff report covered most criteria, and then some were not, and not that you should do this. It would be a very lengthy staff report if you covered every specific criteria. But ones I was curious about that we find in the State Subdivision Act, in the Revised Code of Washington, Chapter 5817 and Section 110, you noted that in your staff report. But a couple of those things we may discuss during this hearing today that I'm curious about, that I need to make findings about. And one is schools, safe walking to and from schools, and where the schools are, and is there walking provided, or would it be bus transportation? And another is provision of parks. This again is in the State Subdivision Act. Are there suitable provisions for parks, for public transit? And I guess those are the three issues that I saw that you identified those as criteria, but we didn't have a discussion on those. You may have that information now, and if so, it'd be great to bring that forward. Schools and parks and transit.
Okay, well, we have notified the school district of this application. During the notice of application, the environmental determination, the mitigated determination of non-significance, as well as this public hearing. We have not received any comments back from the school district. We have included as a recommended condition of approval that the applicants construct sidewalks in order to improve safety for pedestrians on Fireweed Street. So that would be my answer to the question about schools.
Do you know how close they might be? Might there be walking to schools from this proposed subdivision?
This is a bus area, I believe.
I will turn that over to our city engineer, Mark Dorsey.
I do not believe that, because we had a project years ago, that Blackjack Terrace, I think it was, that was off of Sherman, off of Fireweed, and there was this is a bust area. I don't think there's students walking from this area. I think maybe the residents can confirm that. I'm looking at Mr. Michelson.
It's a walk area. None of those children would, they'd probably go 3 or 4 miles to walk.
Okay, we're getting into a general discussion here, and this is why I want some more information on it, and I appreciate what Mr. Dorsey's doing. We have gentleman in the back of the room that's mentioning there might be some walking going on. So let's get into this a little bit as we get more testimony, because it's an area that I need to make a finding on.
Yes.
It came out of a legislative enactment about the need for safe walking conditions. So we'll want to take a little bit more look at that. We'll get more information from Mr. Dorsey and from the public and the applicant, and then allow you to respond to that. Related to that is any public transit and any provisions for transit stops, and then parks and recreation. This all sort of focuses around those that aren't driving and how may they avail themselves of those services. Do you have any information on those other two areas?
In regards to parks, I believe that the applicant has chosen to pay a parks impact fee in lieu of creation of parks facilities.
Through an impact fee, is that what I heard?
Yeah.
Mr. Nick Bond maybe has information on that. And why don't we do this? We have 4 staff people here. If the 3 of you would remaining, do each of you swear to tell truth and testimony you give today?
I do. So, the Parks Impact Fee has been adopted. It's a GMA-based Parks Impact Fee that is due at the time that a building permit is proposed. And so that is adopted and has been in place since at least 2011 or 2012 within the city. And that goes towards the development of the city's park system.
Mm-hmm. Are there impact fees also for other aspects that are affected by development,
Correct.
such as schools?
We have school impact fees that have been adopted that are collected directly by the district, and we require that sign off from the district before we issue building permits. And there are traffic impact fees, which we adopted in November of 2015. It's fairly new, but those are in place, and there's about I think $65 or $70 million in projects citywide to improve transportation capacity.
Okay, and thank you. That's helpful testimony. This is something that's relatively new to the city of Port Orchard, the concept of applying impact fees. And it's good information to have as part of our review of a plat because of the need to make findings that there be suitable provisions. So the answer on the parks question is yes, this applicant not providing park space within the proposed subdivision, but would contribute to a park fund for development of parks in other areas of the city.
Yes, that is correct.
Okay, thank you. And finally, the area that I know that you noted was a criteria that we have to look at, but I didn't see information on it. You may know, or others in the room may know, is about any public transit. Is there anything nearby that would provide that?
I believe there is a Kitsap Transit bus service along Sydney, which this project is located on Fireweed Street, which directly connects to Sydney.
Mm-hmm. Okay. Very good. And then just a couple of fairly minor kind of housekeeping things. The exhibit list, which you may or may not have prepared, it doesn't have an Exhibit 21 indicated on it. If you look, it goes from 20 to 22. But I want to note that there is actually an Exhibit 21, and we should make note of that so that no one's confused by it. And it's
There is an Exhibit 21 in my copy of the record.
Yes, I have that too.
Yeah.
It's additional documentation that appears to be provided maybe by the applicant.
Yeah, my Exhibit 21 is showing a non-binding letter of water availability for the project from Pace Engineering, who's
Okay.
a consultant for the city of Port
And
Orchard.
that's what I was checking. We have the same complete record. It just got missed in the exhibit list, so no big deal there.
We
But
can
we just
make that
wanted to
correction.
note that we have that. And then I wanted to just ask about the MD&S. Exhibit 18. And again, not a major, it's just a minor housekeeping thing, but I note that it, on the face of it, on the second page, page 2, it was signed on, looks like the 17th, but then the last paragraph says issued on January 22nd.
The reason for that is that we can only issue public notices on Fridays. We need to publish our notice in our paper of record, which is the Port Orchard Independent, which only goes out on Fridays. We need to get those documents to the Port Orchard Independent on the preceding Tuesday. In some cases, we will just go ahead and sign the document, get the document complete, and get it ahead to them. But we do need to wait to officially issue any sort of determination or notice on the Friday, because that is the day that the notice publishes in the paper.
I knew there'd be an answer, so thank you. That's very helpful. And that later date then is the one that begins the
Yes.
timing for appeals or comments.
Yes, it
on
does.
the environmental review.
There's a full 14-day period after that issue date of January 22nd, 2016.
Very good. That's the date you used to say there were no appeals.
Yes.
Great. Thank you. Oh, I did have one other question, and it relates to recommended condition 34. And I'm mindful that not all of these recommended conditions are ones that you, as the planner reviewing this, sometimes you're taking them from others, and you're not developing each of those on your own. But the condition 34 speaks to water, and it's labeled source requirements, and it reads as follows, quote, "The city is relying on Bremerton's 260 zone source of water until the Well 10 project is online. The impoundment of water in the Sedgwick Reservoir should be resolved by the city." And I read that, and I thought, well, that sounds like maybe some factual statements, but I had trouble seeing how it would be a condition of approval. Maybe you or someone else could explain that. It looks like Mr. Dorsey is really eager to explain it.
This has been explained to me by the water manager for the city as something that they added in here, that currently we are relying on this Bremerton's 260 zone. There is adequate water supply for the site, and in the future, when the Well 10 project comes online, then that the water service for the area should be improved by that project, was my understanding. I'll let Mark answer that.
Yeah, I think this is probably more information that needs to be in a condition. The fact of the matter is that the city has available water. We did renew the city of Port Orchard's been purchasing water from Bremerton for years. We've just recently revised and updated that agreement to be not based on emergency need, but actually providing water. So I think the water manager is just being more thorough. But the reality of it is the city has adequate source for the development. So that language could be struck if it's just excessive.
Good. Well, that's helpful. It's interesting as a fact, but it doesn't apply as a condition. We're looking at preliminary plat, what must be done before there can be final plat approval.
Yeah.
So thank you. I think it's good information to have. But at this level, we're looking at, is there a suitable provision for water supply? Was water available? The answer from both of you as planner and public works is yes. So this maybe is more appropriate as a finding and is not needed as a condition.
Yes.
Thank you. I just want you to know I'm reading this stuff carefully before we come to the
You
hearing.
certainly are.
And you've got good responses to each of my questions, so thank you for that. Oh, I keep finding one other. and this relates to the homeowners association. This is a proposal to subdivide into 12 lots,
Yes.
which is a relatively small homeowners association. And you reference the need for a homeowners association to be involved in maintenance of a drainage system.
Mm-hmm.
But I'm not sure we actually have one required to be formed. Is that something that would be required under ordinance, or how do you see that moving forward? I didn't find in your ordinances any reference to homeowners association. And sometimes there is, but not in the Port Orchard Municipal Code. So that can be handled in conditioning, because it really is an option whether there's a homeowners association formed or not in many cases. Was it your assumption that there would be one formed?
My impression was that there would be a homeowners association formed in order to take care of that shared stormwater facility.
So it might be appropriate to specify that in a condition, that there shall be one formed, and responsibilities would include only the drainage system, or is there some private roads too that would need to be maintained?
The roadway is proposed to be public.
Yeah, and I guess a point for clarification
Dorsey.
for me, I'd always thought that the requirement to establish a homeowners association was a state requirement.
Mm-hmm.
That's always been my understanding. So I don't think it's specifically in our municipal code.
No, it is not. Okay. Good. We'll just make sure that we're all on the same page, that the applicant anticipates doing that, and that then the only responsibility of the HOA, it seems, would be maintenance of the drainage system. No need to maintain roads or parks or any other common areas, but the drainage system.
That is correct.
Well, thank you, Ms. Davis, for your preparation of the recommendation and report. It's evident that there was a fair amount of time spent on that, and it really helped get us to this point where we can hold this hearing. And particularly, I wanted to note your facilitation between surrounding property owners and the applicant to address issues I referenced before that are in Exhibit 17. And one of those areas of concern was about the ownership of property and where the east property line might be. And is it your knowledge that that has been resolved, and that's why we're moving forward today with this hearing?
It is in letter, I believe it's 19. No, it is not. Letter in Exhibit 17, we received a letter that we admitted into the record stating that there were no longer property disputes.
Mm-hmm.
That there were
And
resolved.
I'm thankful you recognize that as a serious area to resolve prior to a hearing, and that I've convened hearings and it's raised by a surrounding property owner that there's a dispute and we really can't move forward until that's resolved. So thank you for facilitating resolution of that. And with reference to that, Exhibit 17, the letter you just noted, it again, it looks like it's a very good process that went through here. The comment letter that came in early on, and then Exhibit 17 contains that comment letter with a number of areas struck, strike-through formatted, and then a highlighted parenthetical that says resolved at a meeting between neighboring property owners and the applicant. Were you a participant in that meeting?
I was not.
Okay. So we got information resolved. We're not quite sure how specifically it was resolved. We're relying upon this document. And one thing the applicant and any citizens that are here that were involved in that meeting might address is, were there any additional conditions that might have come out of that? Some of these, for example, the height of any residential structures, the resolution of the property line dispute. Some you may have decided should be captured in conditions of the preliminary plat or at least in findings related to preliminary plat review. So I'll want to hear about that from any citizens or applicant, because the city staff was not involved in that, but I do have the document in front of me and want to make sure I capture whatever agreements were reached between applicant and neighboring property owners. It's always best when those can come to an agreement rather than us imposing how it should be resolved. So I'm thankful that there was resolution, but I want to make sure that it's captured so that there isn't any misunderstanding down the road as this moves forward as to just exactly what was agreed to. So we'll turn to citizens and applicant for that. Thank you, city staff, for your information. And it's now appropriate that we get information from the applicant. There's two people here at the applicant table. We'll ask you to take the oath. And do each of you swear or affirm to tell truth and testimony you give today? If so, please say, I do.
I do.
Thank you. Who's on first? What's on second? Okay. Good morning, sir.
Yeah, my name is Fred Cagle, Cagle Engineering, responsible for putting the application and preliminary plat together for M&P Builders. We are in agreement with the staff report for the most part. We have complied with the city code for comprehensive plan for transportation needs. We went through the SEPA process and got a mitigated DNS on that, which indicated that we'd complied with all the code of the city.
Mm-hmm.
I would like to address a couple items in the recommendations that, to the hearings examiner for 4 conditions.
Okay.
And the first one would be that the item number 7 on page 9, we're requesting that the shall not be construed to mean approval of the total number of lots or configuration of the lots and tracks. I agree with this condition. The only thing that I'm concerned about is I would like assurances that if for some reason that we do need to modify the lots for some reason, that is not going to kick in the need to amend the approved preliminary plat. Later on in item number 9 on the same page regarding stormwater, where the condition says that lots 10, 11, and 12 may be reconfigured, and I construe may as being permitted. And there again, that if for some reason that we need to modify in this particular location, that we would have the assurance that a amended approved preliminary plat would not be required. Excuse me.
Yeah, I can see the basis for your concern. In fact, it almost as if they could be in conflict, whereas condition 9 says, sure, you can reconfigure lots to accommodate stormwater, but condition number 7, if you read it really strictly, says may not be reconfigured. So it's something we need to get more information on. My guess is it's this major, minor, or significant, insignificant, which is typically up to the city staff as to make that determination. But let's find out if you want to do it as a dialogue. So you have other concerns as well, or should we get responses to this one?
We can address this at this particular time, then I can move on.
Okay, let's do that. So, Ms. Davis or Mr. Bond, you're in that department that would look at any revisions to plat, and I think the question is what triggers a plat amendment, or maybe Mr. Dorsey has information on that. I'm not sure it's anything we can be very specific about, but any thoughts on that as you hear the applicant's concern about condition number 7?
Well, I'll jump in first. So,
Dorsey.
I know that the city previously did not have an amendment allowance within the code, and the state code is very strict with respect to amendments. It's something that the city hadn't addressed in the past. Other jurisdictions like the county have a more liberal interpretation, I guess, of the code. So we originally were trying to, in essence, comply with the fact that the city now has a major or a minor amendment. One's administrative for a minor. You have to go back to the hearing examiner for a major, correct? And so I think the first condition 7 was trying to comply with that, the fact that we do have an amendment process in the city, but then under the stormwater, understanding that with this being an infiltration system and having a final design component, that it may include some potential changes, whether they're minor or major. I would assume minor, based on the extent that the applicant went through for their infiltration analysis, to allow those lots to be reconfigured to address just the storm drainage. So even though they appear to be in conflict, I would say that 7 would say, could be added to say other than 9, number 9 below, or something to that fact.
Well, that's helpful. The city response, as you heard, Mr. Cagle, is certainly as you get more detailed stormwater analysis, that reconfiguration of that particular set aside for stormwater would be appropriate. But there's then it's a new amendment process, Mr. Bond, is that what we're looking at?
Correct, and I've pulled up the code here, and it's section 2640-100A1, and minor revisions to an approved preliminary, and I'm sorry, that's actually the binding site plan. I think it's the same for the subdivision chapter. But anyway, it is minor amendments are defined in our code, and under a minor amendment, you can't change the conditions, you can't change the road layout, you can't increase the number of lots by more than 5%. So I'm not actually sure that condition 7 is needed. I think the intent of condition 9 was to provide additional flexibility in the approval so that if the stormwater tract needed to be enlarged, that lots 10, 11, and 12, the boundaries could be adjusted it's very clearly defined that those can be adjusted to accommodate changes in a stormwater design as they go through their final engineering on that facility.
Okay. Well, that's helpful. Mr. Cagle, does that help in addressing your concerns?
Excuse me, I believe so. It was my opinion that we would address more a liberal point of view on this, that we would have some leeway in modifying, lot layout, dimension, but still in conformance with the preliminary plat, being a land use approval process for X amount of lots with a road system, with infrastructure, that we would still be falling in line with that approval. When we get down to specifics, we need leeway in design processes. So my hope was that we wouldn't have to go through a preliminary plat, a modification amendment per se,
Right.
if we meet all this.
Right. But the city's reference, Mr. Bond's reference to the section in the code that addresses what's minor is helpful. And it seems to me part of this is this transition as the city of Port Orchard's adopting a new subdivision code and struggling with how do we define what's major and minor, that this was an effort to capture it in that condition 7.
Right.
So,
and during this review process of the new ordinance, we're hoping that we can, come to some kind of agreements on these definitions. What does constitute it, what doesn't.
And Mr. Hunter, I did find the correct reference for the definition of minor preliminary plat amendment, and it's under in the interim ordinance number 15-15, 26.2100A1 defines what a minor preliminary plat amendment is. And so the condition number 9 is intended to allow for a greater degree of flexibility to where you wouldn't have to apply for a minor amendment, which still has to be processed in-house. So this is a greater degree of flexibility than even what is allowed under the minor amendment process for the stormwater facility and lots 10, 11, and 12. Any other minor adjustments to boundary lines within the plat could apply for a minor amendment, and that would be processed administratively and could be approved administratively as long as it doesn't exceed the threshold for what is a minor amendment.
Okay, well, that's very helpful. I think that addresses your concern then.
That's the way I was reading it.
Yep.
I just wanted to confirm that, you know, we were going to be assured that that wasn't.
No, I really thank you for raising that. I had that same question, and it's been very, I think, addressed very adequately by city staff as to what the intent would be. So we'll keep that condition 7, but reference to the section Mr. Bond just gave us as amendments are allowed if consistent with that section of the code. Okay. Any other concerns you had as representative of the applicant?
I guess during the discussion on item number 17, where you were questioning the homeowners association, I guess did you come to some kind of conclusion what you're thinking that condition should be?
My question was whether it seemed the city was assuming one would be formed, and I don't know if you've had that discussion with your client about forming a homeowners association. Is that something that would be normally planned to do? Would you do that? Because the condition of maintaining drainage systems depends upon the formation of an HOA. Right. And that was my question, whether that should be a condition requiring that an HOA be formed for the purpose of maintaining the drainage system.
Well, it would be either an HOA or a modified outside consultant, maybe.
Right.
There has been some private maintenance companies that have been maintaining these storm drainage systems.
Mm-hmm. But contracting with some type of an association of the 12 lot owners.
Well, it could be done just from the developer standpoint at the initial standpoint.
I see. Okay. Well, that's exactly my concern, is that we didn't get along in the process and then find out, now wait a minute, how's this going to be done if there's no HOA? So maybe it's
we're going to have the covenant.
Okay.
You know, that specifies that it's going to be privately maintained, or the developer's responsible for it. Now, how the developer transfers that out after the 2-year period.
And what are you looking at, a condition?
Number 17.
Yeah, it begins, the prefatory clause is, oh, I see where you're going. The owner or homeowners association shall be responsible for maintenance of the stormwater facilities for this development following construction.
This is a standard statement that occurs in a lot of.
Well, I'm aware of that.
A lot of projects, and so.
Right, I'm aware of that, and some cities have a mandatory HOA be formed within the ordinance specifies that. This city does not have that, and so you hit the nail on the head. Would it be directly with the developer, or would it be a homeowners association? Yes, sir.
There will be a homeowners association.
Okay, good. That answers the question. Yeah.
For development, I do have to put a homeowners association.
Okay. And I'm sorry, I didn't get your.
We'll include whatever they want us to include in there.
Yeah. Okay, that's the customary way of doing things. I just wanted to be sure we didn't drop that out.
Thanks for asking.
And you are, sir, I'm sorry, I didn't get your name. It's your client.
I'm sorry, Paul Berg.
You are Paul Berg. Okay, I hadn't met you. I saw your name repeatedly in the document, so thank you. I'm glad you're here today.
The next item I would like to address, and I've discussed this this morning a little bit with the stormwater staff, would be item number 22 regarding the sidewalks being constructed prior to roadway paving. Here again, we have a standard blurb, standard statement that occurs in a lot of projects. But we are proposing pervious sidewalks, pervious concrete sidewalks, which can be subject to contamination if they're constructed too early.
So we would propose that, that particular statement as written would be removed, and then
I'm sorry, which condition are you looking
number
at?
22.
It reads, any required sidewalk shall be constructed prior to roadway paving. This note shall appear in the face of the plat.
Final construction.
Oh, final construction drawings. Sorry. Better quote accurately if I'm going to quote. Thank you. So,
And we would propose that maybe that be prior to final plat approval in lieu of construction drawing or construction.
so now you've got sidewalks before roadway paving, and you'd like that to read prior to final plat approval.
That the sidewalks, be either, constructed or bonded prior to final plat approval.
Well,
Takes out the requirement that we do it prior to paving.
well, let's give.
We have much better luck with these if we kind of hold off on it during some of the construction process and then put it down towards the end of the infrastructure construction. And the city is going to take over these sidewalks too as a maintenance item as part of the roadway, which is required under condition number 23.
I think maybe it helped too to note that when we met this morning with Andrea, she agreed that would, actually she's the one that said that it's probably the best idea. And the whole thing is to try to protect the pervious part. Because it's a lot different than a sidewalk. I mean, it just has holes in it that fill up. And when you have construction going on, you can't always control that. It becomes a nightmare.
Okay. Well, let's find out if the city's had a chance to reflect on this and see if, so Mr. Dorsey, back to you as to whether you have any thoughts on this proposed modification to condition 22.
Yes.
Yes.
I'm fine with condition 22. It protects the sidewalks for the lot development. Now there's the plat development, the actual construction of the homes, and the contamination that can occur during that phase, I think is more of a problem with landscapers and builders not really watching out for the sidewalks, but that's the intent of condition 23.
Okay.
Is to have that 2-year period at which the city then come out and inspect and take over the maintenance once we've determined that the sidewalks are still in working order.
Okay. So when you say you're fine with condition 22, as suggested by Mr. Cagle, Mr. Berg, that it be strike roadway paving and put in final plat? Yes. Okay. Sounds like that will be accomplished. We'll do that. Any other concerns of the applicant about any of the conditions?
On the water section on page 12, item number 32, where it refers to residential sprinklers if required by the fire department. Residential fire protection plan shall be submitted for review and approval prior to issuance of an SDAP permit. We have concerns over that holding up the approval of an SDAP when it is not probably fully known whether the residents are going to be required to have a fire sprinkler system, since there has been no building permits applied for at final plat stage. So we had a little discussion with the staff this morning over that, and Andrea submitted to the fire department to make comment on that, I guess. But
I mean, I can comment on that.
Mr. Dorsey?
So The reason we've added this condition with the requirement for residential sprinkling is we've had a number of developments in the last few years where, as part of the plat development, the water main and the water services were installed, and they were installed per the city standard. But residential sprinkling has to do with pressures in the area and elevations and things, and so we got into a situation where the plat developer was asking the city to go back and tear up a road that was brand new because they had just put in a standard 1-inch service, and that still wasn't adequate, and then they didn't want to have to install like a sprinkler booster because they just didn't have the pressure in the area. So what the position that we took with the fire department was, as part of the design for the SDAP, to make sure we catch any of these potential services where you may need a larger meter rather than putting in a pump at a cost to the homeowner. We're just saying that we want to see the engineer of record who hires a mechanical to look at each of the lots, work with the fire department, and determine, given the pressures and the flows and the elevations in the area that drive the residential sprinkler flow-through system, that you don't have to put in a larger service. And so I think this condition needs to stay. It's not cumbersome. It's basically just having the mechanical sprinkler system that you're going to have designed anyway, just have that work done before we tap the main and put the service in, just in case we have a situation. So, and now in this particular area, we may have, we may have adequate pressures, but I'm trying to.
I can respond to this. So as I've reviewed this before,
and this is, please identify for the record.
Brad Wiggins, South Kitsap Fire Marshal. This plat here, as it's proposed now, is not required to have sprinkler systems in any of the homes, as long as this road stays as a public road. If it switches to private, then all of them would be at that point, which then would require the additional pressure and flows for the sprinkler systems.
The condition can go away.
Correct.
As long as it's clear that there is no sprinkling required.
There is no sprinkler required as submitted as today.
Okay, well then that condition can go away, and anything that has to do with sprinkling, but it should be clear in the record that this project does not require sprinkling, so that then I feel comfortable removing the condition.
Yeah. Okay, well, it's a helpful dialogue, and generally the starting point is, as Mr. Dorsey explained, you want to give fair notice to any developer that this may occur so that you don't get down the road and find out that the water service wasn't adequate. But with Mr. Wiggins here, you're confident that this particular development will not be sprinklered.
Correct. According to the code that we have now in place, as long as we have the turnaround and it's a public road, we'll be fine.
Mm-hmm. And I would like to point out that the condition says if residential sprinklers are required.
Right. So it's not, as I think you're indicating, it's not an imposition. It's more like a fair warning.
Right. So I think actually I'll retract my previous statement that I think the condition just needs to stay. Mm-hmm. Because if something changes and you build 6 of the houses and then suddenly residential sprinklers are required, of course then the plat will be.
Yeah.
Mr. Bond?
Nick Bond, I fully expect that these houses are going to be built before we see a change in the building codes that's going to potentially require fire sprinklers for smaller units than what is currently required. But because we don't know the timing of when houses are going to be built or even when the plat improvements are going to be built, I think it can stay because right now they're not required, and as long as the developer moves forward on building this, it's not required. But when the 2018 code comes out, if this plat still hasn't been built and a fire sprinkler requirement comes into existence, my understanding is that this preliminary plat is not vesting them to the building codes for the houses that would be built later for a fire sprinkler requirement. So right. I would leave it in there, but at the current time it's a moot issue, but it could become relevant in the future if a new building code is adopted that includes a fire sprinkler requirement.
Mm-hmm. An issue.
Not necessarily.
Well, I guess if they didn't build it, yeah. So,
Okay, well, you spawned quite a dialogue between city staff, Mr. Cagle, and I think, though, it's instructive, and I'm concluding that you do have Kitsap Fire and Rescue saying sprinklers not required, and that's probably the way it's going to go, but also city staff concerned about any code changes because there isn't control by city staff over when development might occur. So I'm content with leaving it in, but knowing that
Okay,
you're
well,
not facing that sprinkler requirement.
Would a simple statement as such then that's saying no sprinkler system is going to be required will meet the requirement for the issuance of the SDAP permit?
Well, I'll put in the findings the testimony of Mr. Wiggins that no sprinkling required as long as the road is a public road and it's developed as it's presented. So I think that protects your client.
And provided that the building code doesn't change as well, I think would have to be included.
Right. That's what the condition's designed to do, is to capture that situation where there may be a change in code. Yes, Mr. Berg?
I think what Fred's leading to is a good point. It says for review and approval prior to the issuance of an SDAP.
Mm-hmm.
So if you leave it in, we can't get an SDAP because we're not going to provide those things because there's no sprinklers necessary. And it doesn't, that won't work.
well, no, it's
You have to look at the preface. The first clause is if sprinklers are required. My findings, based on testimony offered today by Kitsap Fire and Rescue, is that no sprinklers are required. So that would move you past that.
Okay, so to comply, if that condition stays in though, like you're talking about doing, by me providing just a simple statement saying, per the hearings examiner's testimony from the fire department, no sprinklers are required, that'll meet the requirement of be able to issue the SDAP permit.
That's right. The finding is no sprinklers required if it remains a public road and the codes haven't been changed. But yeah, that's what would happen.
I think the one thing that provide a little bit of additional dialogue. So you're planning to build this right away, but you got to remember this plat's going to be good for a number of years. And so if you didn't do anything with the plat and you didn't apply for the SDAP yet, because this is going to have how many years? 5, 7, 9?
5.
It's back to 5 years. Let's say in 2 years the building code changed and suddenly you did have to have sprinkling regardless of the road configuration, then this would still be applicable because the code changed relative to, because you can't vest, and correct me if I'm wrong, Mr. Hearing Examiner, you can't vest building related code. So the code could change in 2 years if you didn't already have your SDAP. So
I have no problem with the condition. It's just how it's going to be applied.
I've got the answer.
Yeah, okay.
It's in a finding. No sprinkling currently required and will not be if road remains public road, access road, and codes do not change. So that protects your
But once the
client.
SDAP is issued, then that goes away, right? That's what Mark just said.
That's the way it reads. Yeah. We don't want to engage in too much speculation. I think it's all the testimony is in your favor, but the city's concern is if you delete a condition, it sets kind of a precedent and it may cause problems if there are code changes. So I'm ready to move on. I don't think you're going to have problems with this.
I got one last item. Would be item number 36, where it says the developer will need to sign a DE, Developer's Extension Service Agreement, per city requirements. And I question whether that really needs to be in, because there should be no extensions from any of the infrastructure that's in place at this existence and what is planned to be extended into the cul-de-sac road. So the sewer and water extensions in from the existing sewer and water and fireweed will be dead-ended in the cul-de-sac road, so there should be no need for another developer's extension.
Okay, and it appears to be a standard condition, and your point is, given the location of this particular property, this should not be needed. Is that agreed?
No, that is an extension. If you're extending the main to the end of the cul-de-sac in a public road, that water and sewer main are public, and that's an extension of the public water and sewer system. All the extension agreement is saying is you're going to build that water and sewer line to the city standards. This is a non-issue. I don't understand what the issue is with
Well,
that.
I'm reading it to mean that future hookups.
No,
Like a normal developer's extension agreement.
No, this is simply any time you extend the main, you have a developer's extension agreement that basically says you're going to build this to the city standard. You're going to use ductile iron. You're going to have a certain.
Yeah, we
That's
build
all
it
this
to the
is.
standard, but if anybody, there's no need for it to be extended any further. That's the way I'm reading it. So I'm reading it incorrectly.
No, this developer's extension agreement is saying that when you extend into this cul-de-sac, you will build per the standards. It's not saying that you're going to have to extend it any further. This is just saying the piece that you're building.
As long as we comply with Chapter 11 City Handbook.
Yes.
Okay.
Yeah, that's all that's saying.
Okay.
And if it's helpful, what I hear is that we don't have this extension agreement in front of us, so that's where there's some confusion. Mr. Dorsey's explained that all that does is require that any extension be built to city standards. So that would clarify the condition, and we can add that to make certain it doesn't do what you think it might do, because we don't have it in front of us. Okay? Any other concerns with recommended conditions?
No other concerns with the conditions. The only thing I would offer would be some input as to the busing of students. That I believe
Yes.
that there is busing going on in the neighborhood for the elementary school. The middle school is only about a quarter to a half mile away.
Well, that's a question I raised early on with reference to the approval criteria in 5817-110, that I'm required as decision maker to make a finding that there are safe walkways to and from schools. And you say the middle school is about a quarter mile away?
Yeah.
And
And our development is providing sidewalks in front of the development. There are no other sidewalks to the school per se on Sydney Avenue. And I believe that the elementary school kids are being bused.
is that nearby? Or do you know where the elementary school is?
Are you talking about Cedar Heights?
Yeah.
That's more than a quarter mile away. That's,
By the Crow, it's only a quarter mile.
well, this is a mile walking. My understanding, and we can have the public testify, but my understanding is this general area South gets out, and it would be nice if they would have responded. But my understanding is that all elementary, middle school, and high school kids that live in this area are picked up by bus.
And I would further add that
Bond?
I think the sidewalks that are being constructed are going to facilitate pedestrian access to a point at which kids can be picked up.
Okay. So the information I'm gathering is currently in this area, and it's a developed area, so we know that all students are bused. Schools are more than a mile away walking. So in that case, busing is appropriate, and applicant is improving the frontage with sidewalks that could serve as a bus stop area coming out of the cul-de-sac plat and waiting for the bus.
Correct.
Okay. Well, Mr. Cagle, as you are testifying here, did you have any, you're getting now kind of into this agreement area with neighboring property owners. Do you recall anything coming out of that meeting that would result in the need for some additional findings or conditions to capture that agreement?
Well, I don't know which document you actually have in front of you with reference to that meeting.
It's Exhibit 17, which
And I don't know the exhibit, I'm not privy to it.
I think we can hand you a copy of that. It's the initial comment letter, and then it has in parentheses at the end of each paragraph, resolved.
I think I can answer that.
Mr. Berg?
We'd like to put the condition in there, and I had sent an email to Jim, one of the neighbors, about it, after we met, about a fence that goes along, I can give you the email, the fence that goes along 7, 8, 9, and 10, and how it's going to be constructed. I can give you the actual email, and then that we're not going to construct 3-story homes on 7, 8, 9, or 10. And that the property line shall be the current surveyed property line. Would you like that?
Well, yes, I think I would. But maybe let me do this. We have some citizens here that might want to testify, and we'll see what they say, and then let's come back to that to see if that they just heard it, see if that captures what they thought was agreed to as well. Ms. Davis, did you have anything?
I can provide a copy of that letter.
Could we see 16 and 17?
Yes, Ms. Davis is bringing that over to you now. And while she's doing that, let me get to citizen testimony to see if anyone that's here wants to provide comment or has questions or concerns. Anyone want to come forward? We do have at least one individual. Sure, come forward at this time, and we'll get your comments as part of the record of the review of this preliminary plat application. Good morning to you.
Morning.
I'll ask that you take the oath, and do you swear to tell truth and testimony you give today?
I do.
Thank you. And your name, please?
My name's Jim Cunningham,
Jim Cunningham.
and I live in Garden Drive, and my backyard backs up to the eastern plat.
Okay.
And as he was referring, and you have the paperwork, I guess, we met with Mr. Berg, and we had some issues, and we think we have them solved. And he's referring to this letter. I think you have it now.
I believe I do. We're going to
It
make
would be an email that
we'll make sure we all have the same
Email that
thing.
was sent to Mr. Michelson, myself.
Yes, I have an email, and then attached to it is I have a December 21 letter that I think was updated. It has resolved at the 1/12/2016 meeting. January 12, 2016. It's kind of sprinkled through, and then the email is dated January 13th, 2016. CC to you, Mr. Cunningham. Is that the one you're referencing?
not the one I'm referencing. You wouldn't, unless they gave you a copy, you wouldn't have it unless, because I haven't given you.
The applicant did receive a full copy of the record, including item 17.
Yeah, from Larry and Cindy Mickelson, January 13th, 2016. To Ellie Davis, CC to Mr. Cunningham. Subject, Stephanie's Meadow plat. Is that, Mr. Cunningham, is that what you're
Well,
speaking to?
yeah, that's what I'm referring to. The email here that I'm holding now, it said, results of meeting that we agreed to abide by in the developing of the 12 subdivision called Stephanie Meadows. And number one, an 8-foot high cedar fence to be constructed along the back surveyed property lines of future lots 7, 8, 9, and 10.
Okay, and I don't have that. The one I have is referencing, we settled at a property line.
Yeah, the property line issue was involved in this, and
Well, okay,
we've kind of eliminated the property line problem by agreeing to these items.
all right. Let's hear the items you agreed to. They may be the same that are in this email.
It's an 8-foot cedar fence along future lots 7, 8, 9, 10. And it's to be tied to existing fence in one of the subdivision lots behind Stephanie Meadows. Well, that would run, I guess, south to north, and there's a fence up in the north end it would butt into.
Okay,
And the owners would pay half the price of the fence. on the smooth side of the fence will face the owner's lots in back of Stephanie Meadows. The other agreement was no 3-story homes shall be constructed on lots 7, 8, 9, and 10. So those are all the homes that back up to us in Garden Drive.
Mm-hmm.
And we agree that the property line should be the current surveyed property line.
Okay.
Which has always been there, but we had issues with the former owner of that property because he had barbed wire fences, onto us for years.
Okay.
But that's been taken care of now. And in addition, my concern was been the water drainage, which is really a problem, particularly this year. But they've agreed, another letter has agreed to confirm that M&P Builders agree to construct a curtain drain on lot 10 at Stephanie. That's kind of a modification from everything else he has in the plat.
A curtain drain on lot 10.
Across the back of lot 10, yeah. And what that's doing is much of the drainage, or the water, there's a hard pan in that area. And the water hits that hard pan, and it wants to migrate to Garden Drive.
Okay.
And I have a curtain drain on the back of mine. And it doesn't work much, but this year it worked. And what he's doing is, on his property, doing the same thing to move that water down to the drainage pond.
So the curtain drain is to intercept water that's moving in which direction?
The east.
Okay, any water moving east. And then
and
direct it.
South to the drainage pond.
Got it. Okay.
So that just kind of a secondary protection for us.
Mm-hmm. Okay. Okay, so those are the areas that you've come to an agreement with Mr. Berg. And as I understand it, you're proposing capture those in conditions or somewhere in the decision so that they can be referenced in the future if anyone else owns the property or if you...
You need to...
Do you have that in a written form that... Could that be submitted for the record?
Yes.
Okay, do you have just that one copy, or is it something that...
I have a second copy, if that would work well for you.
I got copies at home too, so...
Looks like there's copies all around the room, except the city doesn't have it and I don't have it. Okay. So we will...
We'll make a copy of this.
We'll copy that and include that in the record as Exhibit 34.
This is the one that says about the curtain, right?
Yeah, it's on the back of the one I give
You can submit both of those.
So Exhibit 34, and this is an email dated what date?
January 12th.
Yes.
And I'm going to refer to it, mark it as Exhibit 34, and it's kind of your agreement email. Is that the way to reference it? Okay. And thank you for bringing that forward. So looking at this and listening to your testimony, and then we're going to turn to Mr. Berg here, this is clearly specified in condition language, 1, 2, 3. And then I think the curtain drain, is that on the next page? Okay. So you're asking that these 4 be added kind of as a conditions. Okay, Mr. Berg, is that consistent with your understanding?
Yes.
Great. That's very helpful. City have any issue with any of these conditions?
No, we do not.
City agrees they're appropriate. Well, that's very helpful. Thank you for being here today, sir, and bringing that to our attention. Anyone else that has any comments? Yes, if you want to come forward. Good morning to you.
Good morning.
Can you please take the oath? Do you swear to tell truth and testimony you give this morning?
Yes, I do.
Thank you. And your name for the record,
It's
please.
Gwen Brenton, B as in boy, Rentin.
Boy, I didn't. Could you do that one more time?
Too fast for you. Brentin.
Oh, okay. Thank you. Gwen?
Yes.
Great. And what do you have to say about this?
I just want a clarification is all. I was looking at page 9, number 9, about the stormwater.
Mm-hmm.
And I just want to clarify that if this stormwater facility is adjusted, that won't change the structure in reference to the property line between us and the, we also share the east property line of the property.
Okay.
And I just want to clarify that those structures won't be any closer to our property line than they're currently proposed.
Okay, I think I get it, and you heard that discussion about reconfiguring and stormwater areas may move, and that raised in your mind a bit of a red flag. I hope they're not moving closer to where I live.
Exactly.
Well, Mr. Kegel or Mr. Berg, can you give any assurance to Ms. Brenton here about that?
No, the normal setback for a facility from a property line will be maintained, which it was proposed in the preliminary. It will not move any closer.
So what she saw, what you've reviewed on that plat
You
map.
are the lot that butts fireweed?
Yes,
Okay. What's your husband's name? Rod?
Rod, yes.
Okay, yeah. No, it
Okay.
won't.
I just want clarification that the
No,
structures won't be moving any closer.
No.
Yep, you're getting even more than clarification, you're getting a commitment. Will not move any closer.
Perfect. And I also wanted to clarify, lots 7, 8, 9, and 10 are the ones that are going to get the 2 stories, but not necessarily 11 and 12?
That was the agreement, yes.
Okay, so we could get 3 stories there on 11 and 12.
Yes.
Would you like to change your mind on that?
Well, and I'm here. It's let's make a deal here.
I really don't have any problem with that.
Okay. Well, that makes it easy.
Yes, it does.
What you wanted added? What 11 and 12 to that list? Because the agreement now says no 3-story homes constructed on lots 7, 8, 9, or 10,
Right,
and you
that's correct.
you just made a deal.
I did, thank you. Thank you very much.
Well, thank you for raising your concerns and having them addressed. Anyone else here from the public that has any comments? Okay, I think we've completed the public comment. I do want to give an opportunity for city response or any further applicant response. No further city response?
We have no additional information to add.
Okay. One thing I'm curious about when we talk about 2-story or 3-story, that's an unusual reference in the land use regulatory area. Typically, it's how many feet. And do you know, Ms. Davis, what the zoning code allows for height in this area?
33 feet.
33 feet, which typically would be
3 stories.
3-story. So you're actually agreeing to something that's more stringent than the zoning code. But that's great. If we get agreements that satisfy neighborhood
But
concerns.
They've all seen the 3-story, they know which one I'm referring to. That's fine with me.
Okay, very good. All right, well, anything else from anyone here? I'm about to close the record, going once, going twice. At 11:25, I will then close the record on this application. I want to thank you, city staff, for your thorough preparation. Thank you, applicant, for your meetings with neighboring property owners. That it's not that typical that there is agreement reached prior to the hearing. But Mr. Cunningham, you were involved in that as well as others, and really appreciate that you approach that with that mindset of let's come to an agreement, because ultimately that's what land development is about, is fitting into a neighborhood and allow a community to develop in a way that keeps the quality of life for existing residents and allows for others to move into that and contribute to the neighborhood in a positive way. So I'm convinced that's what will happen here. Mr. Berg's intent is to do just that, and you've come to an agreement that allow that to happen. So my pleasure will be in writing up this approval with the revisions as we've discussed this morning, and I'll do that within the next 10 days. We are now adjourned.